when we're talking about, well, it's too late. The person didn't lose capacity, but they died now, and they have no estate plan. Now what's going to happen? Well, clearly it's too late for them to do an estate plan. So whose estate plan is in place? It is the state ordered estate plan. And what does that look like? Well, this is called the laws of intestacy. Every state has laws of intestacy. In Washington in particular, which is what I'm discussing, the state laws say where assets will go on somebody's death if they don't have a will or other estate planning document or anything else that directed where the assets go. So basically what that means is that if somebody dies without any will or other direction, their assets go to their closest family members. Their closest family members, if they're married and everything is community property, means everything goes to their spouse, which is probably what they wanted. As an estate planning and elder law attorney, there's a lot better plans in place than that, including making sure that the assets are protected for the surviving spouse. We'll get to that later. But nonetheless, a married couple and everything's community property, everything goes to the surviving spouse under the laws of intestacy, which is the state's plan. If it's a blended family, it gets a little bit more complicated. We then have to identify what's community property versus what's separate property, because when it's separate property, half of it then goes to the surviving spouse, half of it goes to the kids from that prior marriage. And it goes on and on. If a single person, if they have kids, their assets go to their kids equally. If one kid has passed, then it goes down to their children as well. If they don't have kids, it goes up to their parents. If their parents have died and they had no kids, then it goes out laterally to brothers and sisters and possibly nieces and nephews. So I think I said I was going to try to make this less complicated. I realized I just made this more complicated because I'm explaining the laws of intestacy. So we do have a chart that if you're interested, we'd be happy to send it to you about what the laws of intestacy in Washington look like. Just reach out to us. But what I would say is that without a will, there is a high likelihood that probate is going to be way more complicated than had there been a will in place. And when I say more complicated, it's going to be more costly. There's going to be more angst, more uncertainties, more complexities. So by the person having avoided during their lifetime doing an estate plan because they died without one, what they've done is they've kind of transferred the work that needs to be done to those who are the survivors, rather than doing it themselves during their lifetime because they procrastinated, they avoided it, they didn't want to do it, or perhaps they died early. Who knows what the situation is? The family members, the survivors, are going to have a lot more work to do when their loved one passes.